Hello, everybody. Guys, I had a sob sit tonight. Not just in the wild, at my house. I'm not kidding you. The guy that I hired to haul away the lumber pile, as he was hooking up the lights to his trailer, he was telling me how cops around here don't like him because he doesn't have a license. Child support issues. He was a real nice guy, though. I'm going to start with that. But then he says, constitutionally, you don't need a license to travel. In my head, I'm going, this is not happening. But my mouth, I can't control it. And I started with something along the lines of, don't you dare come at me with that soft sit BS. He goes, no, I'm serious. I said, I am too. I run court cases for a living, and one of the main absolute joys of my channel is watching them get their window busted, hauled out of the broken window, and tased for their dumbassery. And he's like, but you don't need a license to travel. It's in the Constitution. I said, yeah, you don't need a license to travel, or you have a right to travel to any of the 50 United States without having to show a passport or other documentation. You can travel anywhere you want. That doesn't mean you can do so without having a license that every state requires. I said, it is state law that you have to have a driver's license to have a motor vehicle on the public roads, whether you're traveling or in commerce. So I had to throw that in there to let him know that I knew what I was talking about. And I told him, I'm like, you won't win this one, buddy. We had a delightful conversation after that about all of his court woes. And I told him, I said, you are a walking case study for my channel. Did I offend him? I don't know. I paid him quite well, so hopefully he's okay with my mouth. I could not believe that I ran into one in real life. I couldn't believe, and that he thought he was gonna educate me. Oh, it was so good. I couldn't believe it. Oh, he hauled away half the wood pile. He's coming back tomorrow for the rest of it. Provided he doesn't get pulled over. Oh, man. Oh, good times, good times. And then also today, Ava, our little chunky butt, fell at the corner of the bed, just her bottom. She had her paws up on the top, but she couldn't figure out how to get back up on the bed. She was stuck. All of a sudden, I hear this sound that kind of sounded like excited, but also terrified. So at first, I thought she saw another dog out the window, and then it got worse and worse, and I'm like, Ava, what's up, girl? And I go out to the bed, and she's in the corner doing one of these. So I had to climb on the bed and reach over and give her butt a boost out of the corner. The bed has to be enough away from the wall because, like, it's got like the air hoses and stuff that are underneath it, and it says you have to have so much clearance. And then, like, it also has the head that raises and lowers. So, I don't want to mess with where they put it. Like, they know the instructions. But but seeing her hang off the bed like this, it was not funny at all. No, no. I I think it might have been, but it was also comical. It was. I'm not gonna lie. I laughed. The guy that is hauling with the handicap ramp, he was nice enough to help me. The couch that used to be in the studio, I wanted it out on the curb. I posted it out on Facebook Marketplace, free, come pick up. So he helped carry it out to the curb for me. So that was super appreciated. When I cleaned it out, I found Ava's treasure trove. So a while ago, I had gotten her these, like, dream bones, I think they were called. They were stuffed with flavor, and they were rawhide alternative thing. I don't know. There were 6 of them in the couch, along with this super pretty pair of earrings. I'm surprised I found both of them. One of them's missing a post, but they are sparkly. I really like these. They sparkle. So yeah, you might see me with these in after I get them cleaned up a little. Yeah, I like them a lot. So, anyways, it's been my fun for the day. I did get the kitty boxes cleaned last night. Well, scooped at least. Tomorrow, Snitch goes in. I have an empty and perfectly clean cat box completely ready for him. Because the one that he's using, I might just burn it. It's that bad. Oh, hello, Jerry Matthew Boyd. Hello, Nana Laura. Hello, Wire Mother. Hello, Buzzy Pug. Hello, Manny. Hello, Michelle Moreland, sweetie. Hello, Dark Zoomy. A werebeaver. Now, when you find me a wereplatypus, we'll talk numbers. Hello, wolf lore lover. Hello, Megan, welcome. All the ladies in the house. Hello, Mortimer Duke. Excuse me. Hello, Bob 12. Yay, the UK. Welcome. I'm so happy you're here. Hello, Eileen and Carlin. I just love seeing new names and new faces. Makes me so happy. Oh, I know. I'm surprised I didn't say it. I said enough. Where? Where? I gotta get a picture of this. Hey, I had sausage and crackers with Belgian eel mustard for dinner tonight. That was my dinner. And it was yummy. Hello, Shane. Oh, both of my gray boys are really big. I think Snitch might get big too. He's all black. But right now, he's got a big round head like Billy, but a kind of emaciated but slowly pudging up belly. Oh, I know. I might have gotten it on my security cams, actually. I, oh man. Oh, no, because I might need to hire the dude for more. I mean, he's kind of a handy, scrappy little fella. Yeah. I got a lot of crap around here I need done. If I had another man around here that was handy, I mean, then I might consider doing something like that. Hello, Jenny Green. Well, do you possibly have like does it show ads when I start up for you? Because if it shows an advertisement, that's why it would cut it off. Um if you have YouTube Premium or yeah, I think that's the only way. Or some type of ad blocker, then it wouldn't, as far as I know. That's why I don't monetize my videos. That's one thing you guys should notice. There's no ads that run when I stream. The reason is because I don't turn monetization on until after the video's over. If I don't fall asleep at my desk the moment I hit end. But yeah, so I stream for free until it's ended. I only get paid on the rewatches. So, but the reason for that is I would rather have you guys current in the chat rather than get ads popping up during the live stream that set you back. I don't want that. I don't want you to miss anything. And your comments are the best part of the whole entire show. You guys are the funny ones. So I'd rather have you up to date with the video. Hello, Spider-Man. A little bit. Just a actually. Oh man. But it'll be nice to have that big old pile of wood gone. I had the tree stump ground out of my yard and the helper worker dude was the one that was a sob sit. Or I'm gonna say he's sob sit in training. Cause definitely could not have done the script. He just knew the entry level basics of it. He didn't even have the printouts or the trifolds, so we can't fully call him a soft sit yet. And hopefully, I scared him into compliance. Hello, Joey Bag of Donuts. Oh, yeah, your donuts are stale. Does that offend you? Close. Probably close. He did continue to reference how monetary judgments don't count. They can't do anything about them. I should have said that one to him. I did. I did. You can travel anywhere in any of the 50 states you want. You just can't drive there. I'm sorry. I'm sorry. No, I went into, oh my gosh, this is not happening mode. Hello, Squishy. Oh man, if I wait, I'm gonna have a few knocks on my door for compliance issues. Yeah, it's bad out there. It's bad out there. Like the inside stuff, not as bad. I mean, if you're standing outside. But if you're outside and you see the giant mess that is my yard at the moment, yeah, I might get some tickets or complaints or something. That wood pile it needed to go. It needed to go. It was my entire handicap ramp literally just thrown into a pile because I was not told that Holloway was not part of the deal until out in the yard. And I had to tell them that's not my yard. So then the dude was nice enough to at least move it to my yard. Yeah, but the soft sit's doing it for $100, so he's getting it all out of there. A dumpster would have cost me about $300, so I'm okay with it. I'm okay with it. And I gave him $50 for he kicked out some of the posts that were left by the handicap ramp people. And he hauled my couch to the road. So he was like, he goes, I don't know how you knew I needed it, but mine and my girlfriend's phone's been off for a while. I don't know how I knew. I didn't know. I gave it to him before he even told me of his woes. That was kind of what opened up to the woes. Excuse me. Did I get everybody? I got Judge Mogan tonight, and then I got a Georgia money case thing. What are you chewing at? Oh, it's one of the 6 couch biscuits. Hello, it's a Chris thing. scrap wood. Well, I can't now that I talked about him. I think my favorite was, you are literally a case study, a walking case study for my channel. Oh, dag nabbit. I hate when you know. Thank you, Jerry. Hello, Purple Kiv. I love you. Oh, that's 10. That's 10. That's like, I don't know, what do they run? Like 60 or so? It's like 1/6 the way there for one. I don't need 7. I need 6. You know, they say they do say two extra. Count your cats and add 2. Yeah, no, now I have snitch. So now it's supposed to be 7. I have 7. I thought before I had extra. Now I can't say that I have extra, but I don't have anywhere else to put. I'll be doubling and tripling up in the rooms on litter boxes if I add more. Hello, Allison, honey. Oh, he's not my handyman. I just hired him. I did not ask him about jurisdiction. I didn't get that far. But when he was complaining about child support, I told him Michigan laws where you have to pay 25% of what's owed. And I told him about the guy in Monroe County, Michigan that owed over $24K. And he had to pay 25%, and he just sat. For a long time. Pronounced the same. Yeah, I think Wisconsin is 17 or 18. If I remember. I might be wrong on that. And I think it goes up with more children. I think it's 17 or 18 per one. And then it goes up. I don't know what the cutoff is, though. Ava, you are so loud, and I can't even tell you to go to your kennel. I can't even kennel you because Snitch is in your kennel. That's my fault. I'm the one who just couldn't keep the cat outside. I tried. I put it back outside. I did. And then he ran right back in my house. Everybody on Discord saw it. It was not my fault. The cat distribution system claimed me. 25%. Is that at a federal level? Like every state has that max, or is it state by state? Because I always thought it was state by state. I could be wrong though. I don't need it. I never use it anyways. I know, we got the best treats here at the Paw Firm. And Ava has the loudest. Ava, come have some quail eggs. They don't make as much noise. Who? I bet it's Mortimer Duke. I bet it's Mortimer Duke. Nope. It's Joey. I will check my Discord messages as soon as I get the cases going, which is going to be now. But I realized that I forgot to put something on the case. My bad. Oh, let's see here.
Kara Thomaseski.
Yep, Kara Thomaseski.
And sit.
You can sit.
We will go on the record in the matter 23 CM 138, State of Wisconsin versus Kara Thomaseski.
Thomaseski.
The state appears through District Attorney Kevin Schmidt, both of them are here. So Assistant District Attorney Jose Vila is appearing here today as well. We have Joel Feliski, Defense Counsel. Ms. Thomaseski appears in person in custody. We're set today in this matter for the return on warrant initial appearance. I do realize that the parties have reached a stipulation. The court has concerns with that stipulation and the fact that it doesn't give any idea of when she's going to be able to pay the $330.50. And with having this be a warrant from 2023, the court has concerns.
Thank you, Your Honor. In addressing the stipulation specifically, the primary issue at play here is simply that the active case in this matter is what's preventing Ms. Thomaseski from gaining and maintaining employment in order to pay off that ordinance as specified by the stipulation. That is the holdup here, to my understanding.
What was the holdup of her not turning herself in after 2 years having a warrant?
Answer myself.
Yes.
Your county officers were the problem. As soon as I had run into a tribal officer, I could have ran the other day. But when I saw that it was Zajac and I knew that there wouldn't be any extra things added to anything, I did turn myself in.
Let's all be real. You could not have run.
That is the right thing to do.
I know. And listen, I had over the last year and a half tried to work it out somehow from another state. I was living in Minnesota and I actually got hired at the Lake Leaf dispensary for Mille Lacs, but this was preventing, and I've been trying since then, and Joel himself too, to work something out, but I understood that it was about money and showing my face. But I have nowhere to live over here.
Actually, it was about accountability and responsibility for coming to court and then not coming to court and having a warrant for 2 years. That's what it was. Well, actually, this is 2023, so now it's been.
Ma'am, did you read my letter?
I
had moved to California.
correct. Doesn't mean my warrant goes away.
I understand that, but when I tried to long distance work it out, there was no kind of budge on the end of the court in my matter.
I believe what Ms. Thomaseski may be referring to is that I had been appointed while this case was
I
in
know what
warrant.
she's referring to and you referring to, you asked the court to have a Zoom appearance or some type of that and take care of it. The court's concern then is she's in California. How am I going to ensure that the matter is going to resolve or having her appearance or taking care of the matter? That's why.
I had moved back to Minnesota, ma'am.
Here still on, if the court accepts the agreement, and I'll hear why it's in the public interest, knowing you were in California, you weren't in California, this warrant has been issued since, I believe it was since January 8th of 2025. But then there was a different warrant from October 11th, 2023, and then the court quashed that warrant and then gave you another date and time, but then you still didn't appear. So it's not, this has been a multiple failed appearance. So the court needs assurance that you're going to do what the court's going to order you to do to pay the $330.50. So are you living here now?
In Wisconsin,
Where are you living?
I have been staying with George Rainey. He is a double amputee and has dialysis 3 days a week. And I have been kind of stuck here.
Where does he live?
I'm trying.
Right, but where does he live?
Yeah. Oh, in the apartments in Round Lake Reservation. Luck, I get the Luck address.
What's the address?
6th Avenue, Luck, Wisconsin. I'm pretty sure it is. He let me stay there for the winter because last winter I was stuck outside trying to wait out a housing list and get in somewhere because the warrant was preventing me from.
I know, you're
Getting
not
into
helping your case. You're
shelters and
actually digging a
things.
bigger hole.
How?
You're digging a
That
bigger
I'm
hole.
homeless?
That you didn't turn yourself in and say, Judge, let's deal with this when the warrant was going on. But now you want me to go sign off on the fact of having an ordinance violation and not having any guarantee that you're going to pay.
As soon as this is taken care of, I have 2 jobs offered to me. I can go back to the casino in Danbury. I can go to Turtle Lake. Otherwise, I can go back and apply again at Lake Leaf as soon as I don't have an active warrant. They will hire me for the dispensary in Hinckley.
Again, see, that's, you're asking for the court to give you something because you need something. You're not being accountable.
If you think I still have my check, I bought a vehicle to get to work.
I don't care about a check. That's not what I'm looking at. I'm
This is the
about
truth to me.
accountability and being responsible.
That's
This-
why I'm here.
I'm glad. Good. Then you're here. And that's what I'm trying to get at. And the fact that now you want the court to do something for you.
What do you want? Can I give you $100 as a down payment and get out as the ticket? I thought that we had it all worked out that it would be, I
know.
I'm not understanding what she's
Need the
asking
court's
for me.
permission.
I know.
Exactly.
And I'm
so
trying to
what I'm
ask
trying
you-
to get, what I'm trying to get at is the whole fact of why it took you from the first initial warrant from October 11th, 2023, and then the court did exactly what you said and gave you another chance. You failed to appear again on January 8th, 2025. You didn't appear again. And so another warrant was issued. And then that's the warrant that continues to stay out there. You failed to appear twice in this case alone, twice.
Ma'am, when you issued the warrant in 2023, they called me the morning that Katrina Matras had passed away.
I read your letter. I understand it.
I
get
was
it.
stuck on the streets for 6 months and almost died there. When I came home, I was in the hospital.
I'm having enough of her talking.
I
She's
wasn't
not
in-
understanding
Does she
this.
want them? That's exactly why I haven't taken care of it. I was sick.
Stop talking. So here's the deal. I need assurances that you're gonna pay, and if you can pay, great. If not, then another warrant will be issued, and then you'll have to sit and you'll have to do the thing because you're gonna owe the money. But I'm gonna tell you, here's a better deal. Can you get me $200?
I can get you 100 today.
Can you find $200?
I can
Today.
ask.
If you can get me $200 today, I'll waive the rest. And you can be out, and this can be taken care of.
Okay. All I have is $100. I don't want to ask my kids for anything. I really don't have anybody. I didn't want to come back to the Midwest. There's nothing here for me.
Oh, sure. There actually is something here for you. A warrant.
I just want to go to work.
Why is this agreement in the public interest, Mr. Schmidt? Or Mr. Vila?
Your Honor, this, first and foremost, this is a victim case. So this agreement largely stems from the fact that this victim really just wants this situation over and done with. This stemmed from an eviction situation that spilled over to a criminal trespassing charge. This is also a case that was charged out by the previous DA, that was previously charged out by the previous DA, Jim Renicky. The DC has no merit. This is a criminal trespass case. The ordinance is in the best interest as it is a low-level crime. And again, taking into account victim input here, he just wants a fine and for this to go away so he can be done with this. That's why the offer.
Okay, Mr. Felicity.
I concur with this remarks made by the state. Thank you.
Mr. Thomaseski,
Yes.
here's what I'll do. This is where you're gonna have to prove to the court that you understand. You understand this. This was from 2023 and 2 failed appearances. And I get your reasons and I get your excuses and I don't like you rolling your eyes.
I'm
I
not
get
rolling
them.
my eyes. I'm looking at him for whether or not I should talk.
I've read your letters. I understand the situation. Are you listening to me?
Yes. I'm just looking at nothing, so you don't think I'm being sorry.
Okay, I'll take your $100 down. I'll accept the agreement at $330.50, $330.50. $100 down, okay?
Yes.
The rest has to be paid within 45 days, all right?
All right.
But if you can get me another 100,
Ted,
not today. Another 100 by April 22nd, I'll waive the rest.
I'll do you better than that. I have it by the end of the week.
Okay.
Okay.
Ms. Thomaseski, the whole thing here and the whole issue, the reason that I'm having the issue is the accountability factor. I understand and I did, and I read your letters. I did read your letters. I knew you were in California. I knew those kinds of things, okay? The problem is I have to make sure people come to court. That's my job.
10 states away from misdemeanor was, okay, I'll have it by the end of the week.
All right, okay. 100 today, 100 by the 22nd, then
And
the
then-
rest is waived.
And then everything's closed and I can go back to work.
Yep, you should
Okay.
be able to. Don't get in trouble again.
It's on my phone. Thank you. Joel?
All right, we are adjourned.
Right. Come here. Thanks, man. I'm gonna call you.
Okay, okay.
You don't have to call him. Please don't call him. That's not weird at all.
Thank you.
All right, Attorney Green, looks like you spoke with positions 14, 17, 1 and 2.
I've got a consent that I sent on 14, and 1 and 2 will need to be trials.
Okay. All right, let's start with position 1. That is Ms. Webster. Ms. Webster, if you could turn your camera back on and unmute for me.
So, Judge, I don't really know why this is on a default calendar. There's a default issued in February.
I can tell.
Then
I can.
of 2020. Oh, okay.
Yeah, I can break it down for you. So what happened was, yes, there was a motion for default judgment that was granted, and Ms. Webster, I think she wrote in a couple of letters. One, she asked to vacate the default judgment, and we put it on a hearing calendar, and I believe she missed that hearing calendar due to some issues she had with, I believe, I don't want to get into it, but they granted her another hearing, basically. So they undid that default judgment that was entered due to her absence. And so now we're back on a calendar, so we're kind of back to an original motion for default judgment. If that makes any sense.
Wait, you mean motion for default judgment or motion to vacate her?
Her default judgment based on her non-appearance, even though she was in default, but we had a hearing that she didn't come to, and she let us know why she wasn't there. So that
Right.
default judgment was vacated already. So we placed her back on a calendar, but she's still in default according to our system.
Okay, so then if that's the case, Judge, we're seeking a judgment for the amounts pledged.
Got it. All right, and Ms. Webster, there's a motion for default judgment that was filed against you based on you failing to file an answer within 30 days.
So she failed to file an answer, got defaulted against, sent the court a letter begging for another opportunity. They gave her the opportunity and she didn't show up. And now she's back with another opportunity. And I think Ava has to go potty. You gotta go outside? Yeah? Okay. Hold on.
Of being served. What is your response to that?
Well, I do not believe, Your Honor, that I was properly served. I do not recall being served at any point of time. Um, as you said before, we did have a previous conversation with another attorney at our previous hearing, and she advised me she didn't have the correct address. So I was just kind of confused, but I don't believe I was served. I do not recall being served at all.
Okay, so that's not my understanding. I wasn't aware that you had come to one of the hearings. I thought you sent in letters stating why you weren't there.
Yes, and I spoke with you the last time. I believe we met in February at some point in February. I believe it was February 11th or so. And I met with another young lady who was a plaintiff, and she asked, you were ready to, go ahead and figure out what was going on and finish the case that day, but she requested for more time. Um, so you just rescheduled it for this one here.
Okay. All right, so do you have the affidavit of service, Attorney Green?
I don't, Judge, but I'll just say this. This is the first time that it's raised, and you can't just say, I don't remember being served. I mean, you got to have sworn affidavit, and then there has to be more than, the preponderance of the evidence as far as maybe if it's a different address, a water bill, a power bill, a lease. I don't have this one, Judge, but I do know that the entry of service was made on personally served, Judge, back in October 8th, 2024.
Okay. All right, so Ms. Webster, there is an affidavit of service showing that you were personally served. So, I mean, there's an affidavit saying that. I don't have any other evidence to refute that either this wasn't you or, I mean, personal service is hard to overcome. So I understand that you're saying you don't remember. Do you have anything else to offer the court?
Well, in addition to that, Your Honor, in addition to me not recalling being served, like I said before, the previous lady, she had the wrong address. So I'm not sure which address they have. They told me a couple different addresses, and also I don't really I kind of question that they can verify the account because I have yet to see any documentation. And that's what was told that they needed, additional time for to prove that this account belonged to me. But we're here months later, and I still don't have any additional documentation. So I'm trying to, just request at least strict proof before, just being penalized.
Okay. Did you ever live at Noble Vines Drive?
Yes, ma'am, I have.
Okay. So that's the address there that was served at.
Yes, ma'am, but me personally, I've never been served, so I'm not sure who they may have gave it to. And they also do have a lot of occurrences with my address to where they go to my neighbor's home. I had no awareness about the account until I seen my job say that my wages were getting garnished, and then I got the paper stating I had to send in the motion to reply, but it was too late by then.
Okay.
So.
So the description on this affidavit says that I delivered the documents to Angel Webster with identity confirmed by subject saying yes when named. The individual accepted service with direct delivery. The individual appeared to be a black hair, black female contact, 18 to 25 years of age, 5'8" to 5'10", tall and weighing about 160 to 180 pounds. So the person that they served confirmed the name, Ms. Webster, at that address that you said you stated you lived on. Do you have anything else to offer?
Well, I presented all of my evidence in all of the documents that I sent you, Your Honor. I do not believe the account that they're saying is mine. I have no knowledge of, and I've been fighting, to try to figure out whose account it is, but it's not my account. I was not served. They gave me a couple different addresses, but I lived in Clarkson a couple times, so they gave me a couple different addresses, and they also gave me my sister's old address where they said they, tried to send documentation there as well, but I don't live there. So again, I never had a chance to, fight for my case or try to even respond because I never knew about it until State Farm, acknowledged me of that, the case and everything, and I got everything in the mail.
Okay. All right, so I have to weigh the evidence that's in front of me, listening to testimony and looking at this affidavit. I do find that you were personally served back in October of 2024 and failed to file a timely answer, and so you are in default. And the plaintiffs have uploaded the proper documentation making out a claim against you, so I am going to issue a default judgment in this case.
Well, I'm sorry, Miss Williams, but in the last court date, you seen why I wasn't there because I had the documentation from my son, so I never had an opportunity. But I don't want to just say that it's an account that's not mine, and they never gave me any proof. So is there any way I can, speak to, or what's the next steps in trying to, get the actual account owner because they haven't gave me any proof and I haven't seen any documentation on it, any documents with my name, my signature, identification, my ID. I don't even know if they have the, correct credentials to purchase an account.
Okay, so Ms. Webster, when you fail to file an answer, you've admitted to all of the allegations in the plaintiff's complaint. And so Georgia law does not require them to prove their case at that point because you failed to file an answer. So I understand that you're asking for documentation and signatures, but the problem is under Georgia law, we're past that point. So you have to file an answer in order to defend the claim. And in this case, like I said, I find that you were served based on this affidavit of service, and therefore they're not required to give you the information that you're asking for. And when you say that I saw why you weren't here, that's correct. That's why I gave you another opportunity to come to court and go forward with your motion. But once I've heard the evidence from both sides, I'm making the ruling that I'm granting the motion for default judgment. And you may want to seek legal advice on the next steps after a motion for default judgment has been granted.
Oh, okay. So I'm a little bit confused on what that means.
Okay, so you have a judgment against you in the amount of $1,351.22.
You're confused on what it means that you may want to seek legal counsel to answer your questions? I mean, it's a pretty blunt, basic statement. I don't think there was any room for confusion. The judge is saying, I'm not answering your questions. You need to get a lawyer to do that.
Plus $117.89 in court costs.
Oh, okay. And so, okay, I'm sorry to keep asking.
No,
I just
ask
want to
the
be clear.
questions. Okay.
I just want to be clear. So
Yes,
being
ma'am.
though I did not respond, which I had no knowledge of, it's just them saying that they seen somebody that is dark skinned and they serve somebody and that it's automatically me because I don't come to my door without asking who is it. So
But they said, are you Ms. Webster? And you replied, yes. That's why they think it's you.
that's how I know I didn't get served. I don't just open my door for random
Ms.
people.
Webster, I think you're trying to make the argument again, but I've already made a ruling. So
Okay, yes, ma'am. I'm just wanting to be clear because this is kind of there's no proof that it was me other than
Ms.
someone
Webster,
saying that I said yes.
Webster,
So
I've
I
already made a
understand.
ruling on that part.
Okay, I understand.
All right. Do you have any additional questions?
No.
All right. Well, you are excused and we'll make sure you receive a copy of this. All right. Position 2, Christine Horn.
And in Nisqually, your name, sir?
Kenneth Little, Madam, Your Honor.
Mr. Little, all right. Who's representing Mr. Little? Is Mr. Little your client, Mr. Murumbe?
I think
Or-
Roe. I think he's Roe is the one.
Okay, Ms. Rowe, are you there? Is this your client?
Ms. Rowe.
Did I hear you, Your Honor?
Yes, ma'am.
Right, I was wondering, are you representing Kenneth Little in Nisqually?
I'm not, Your Honor.
Okay,
I'll take him. I had taken him on the calendar. I saw that he had been assigned.
Mr. Marimbe is here in court. So Mr. Little, you're Kenneth Ray Little, is that correct?
Yes, ma'am. No, Your Honor.
And what's your date of birth?
2/50/1960.
Okay. You're charged with this allegation from the 23rd, from Monday, of malicious mischief in the 3rd degree and assault in the 4th degree. And that's what we're talking about today, those allegations. And I've got Mr. Marimbe here in the courtroom from Thurston County Public Defense to assist you today. And I will appoint that office, Thurston County Public Defense, after today to represent you as you qualify. So I'm going to turn to Mr. Marimbe.
Yes, Your Honor. I had an opportunity to speak with Mr. Little earlier today, and I advised him on his constitutional rights, and he appreciates and understands them. I also advised him on the possible maximum sentence for the allegations. Mr. Little is seeking public defense, and for today's hearing, we're not contesting a probable cause. And we're asking the court to enter a not guilty plea.
So, Mr. Little, we'll enter that plea of not guilty, keeps all your rights in play, and I will be setting another court date and ordering you back to court. The next step is I'll hear from the prosecutor, and then I will turn back to Mr. Marimbe on your behalf about possible release conditions or conditions on your behavior. And like I say, we'll be setting another court date. So first off, Mr. Clark, on behalf of the city.
Yes, Your Honor, city will be asking for the conditions of no new law violations and the granting of a no contact order that should be in the judge's folder.
And not to hold Mr. Little.
PR release.
Okay.
Your Honor, my mistake.
And I see the no contact order would include no contact with a Kai Carlton sale. Don't go back to the Southwest. And I see there's a request that he surrender firearms to Tumwater Police. Is there something to know there?
There is no allegation of firearms, Your Honor. However, based upon the defendant's, based upon the nature of the charges, the state was going to ask for that to be instated anyway.
See that you, okay, all right. Let me turn to Mr. Marimbe and see what the response is.
Your Honor, we have no objection for the conditions of release.
All right. Well, Mr. Little, you'll be released from custody. And it looks like you're trying to cup your ears. How are you doing hearing me? Do you need me to be even louder?
Yes, ma'am. I have extensive hearing damage.
All right, we're going to make a plan to have a hearing device in court for you. So you'll have to be in person so we can give you that hearing device when you're back in court, all right?
May I address the court, Your Honor?
Well, no, I'm going to have you talk to your lawyer about all this, but
I understand. I just wanted to, for the court's information, tell you that Ms. Rowe was a panel attorney for me a year and 9 months ago, successfully defended a unlawful bus conduct charge. And so we went through this before in District 2, I think it was. So I guess I'm familiar with the process, I guess I'm trying to say. And I had 5 hearings to go through for that, and I was there present for each one in person.
great. And then we can also give you headphones and amplifying headphones that'll help you a lot.
Yes,
So
I'm aware.
your job, you'll be out of custody. Your job is to come back to court, and I'm going to write all this down for you. Don't violate the law in any way, and don't contact that person, Kai Carlton Sale, and don't go back to the loop. And again, I'm writing it all down for you.
Your Honor, I'm not sure where Loop is, but I'm currently unhoused, and I've been living underneath the power lines between Home Depot and Walmart for 3 years. If the Loop is my hooch essentially. I mean, I know Sergeant Brom, I believe his last name is, who was involved in the arrest, is familiar with me there. He came by looking for other things before, said that he's had no problems with me there, but that's where I've been living for 3 years. So I just need to clarify, where that is, and I guess
Let me ask the
Don't bother me because I
prosecutor to
can get
give
my
me a little
transfers.
clarity. Let me ask
Yeah,
the
they don't bother me because
prosecutor
I
for
can get
some
my transfer. I've been
clarity.
there for 3 years, Your Honor. All I'm trying to do
Yep.
is,
Mr. Little, it's okay.
Let me just turn to the prosecutor and see where this is alleged to have occurred.
if,
Mr. Clark, is this near the place that Mr. Little says that he calls home?
Potentially, Your Honor, I believe the assault occurred, well, not believe, but the assault occurred at the Home Depot in Tumwater.
And Mr. Little, you say that you're living, tell me again where it is that you're finding a home?
I'll save you the trouble. You can look me up on Google Map. You can find my hooch on satellite underneath the power lines where they put in the roundabout.
So I went on a little bit of a search, to see what I could see. Couldn't resist. Sorry.
And you can find me there. You can see the rabbit trail. If I had the numbers with me, I could actually give you the GPS settings and you could look it up for yourself. But if you just pull up Google Map on the satellite and look in that little roundabout, you'll see my black plastic covered, tent hooch, I guess, that I've been living in. That's no bigger than this room that I'm sitting in for more than 3 years now.
So that's down Phones
If I
Road,
can't go there
right?
anymore, I have to go somewhere else. So that's all I need to clarify. If you're telling me I can't go back to underneath the power lines, then I got to find a new place to live.
I think I did pretty darn good with that one, man. I think I'm pretty spot on. Under the power lines, between the Walmart and the Home Depot, and you can find him on Google Maps. He said so himself.
Sleep.
Well, so that's down Phones Road away from the Home Depot, right?
No, madam, you're thinking,
Yeah.
I think in central,
Oh.
the Tumwater, between Tumwater, Home Depot and Tumwater, Walmart, where they just put in
That's
the new
right.
Walmart, the roundabout, I beg your pardon.
Let me ask the prosecutor another question. So, Mr. Clark, is that address the Home Depot?
The address in the no contact order was the defendant's address. Your Honor, in order, given the current nature of it, the state will just ask for a simple stay away order from the individual, from the victim in this case, and rescind the no contact order.
Okay.
I'm unfamiliar
And that
with the
would
complaint,
be,
I'm unfamiliar with the complaint. I don't know where he is. I don't know anything about him, nothing. So I have no reason to make contact.
okay, and who would that be?
I don't know, whoever you read,
Okay.
the complainant.
So that probably makes it easier on you, Mr. Little, if you don't know who Kai Carlton Sale is, but don't contact him, don't seek him out. If he works at the Home Depot, Mr. Clark?
I have no reason to go there.
No, Your Honor, he does not.
So just stay away from Mr. Sale, come back to court, and don't violate the law, right?
I won't go to Home Depot and Tumwater, period.
Okay. So what date are we gonna be back?
April 29th.
So you need to be back in court on April 29th at 10 in the morning.
Your Honor, I may need to check with that because the state has a Attorney General's case against an auctioneer that I filed a complaint against 2 years ago, and I'm just informing the court of a possible conflict. I know it's at the end and I don't remember exactly which date, but it's probably within 2 or 3 days of that, but I will confirm that with the court to make sure that there is no conflict because they've asked me to appear as a witness.
Anybody surprised? Shocks? Shocks?
Well, I could make it the first week in May.
Sooner would be better for me, Your Honor, if possible. As long as there's no conflict, I'm just kind of putting that on the radar so that you're aware.
But you think that hearing might be by the end of April?
It is in the end of April, and as soon as I can check my email, I can confirm that. If I could do it now.
Well, yeah, I'm gonna set this May 6th then.
All
We're
right.
gonna get past April.
All right.
So you'll be back May 6th at 10 o'clock. You've got an attorney from Thurston County Public Defense. We'll have a hearing device in court and you'll be released.
Thank you, Your Honor.
You're welcome. That's all for today.
Thank you, Your Honor.
Hello, Ms. Rowe.
She's got a fan.
I appreciate the job she did for me. I'm sorry.
All right.
We will go on the record in the matter 25 CF 98, State of Wisconsin versus Brandon Allen. The state appears through Assistant District Attorney Jose Vila in person. We have Joel Feliski, Defense Counsel, in person. Mr. Allen appears in person in custody.
Guys, I'm not gonna lie. I have no idea what this case is about. I literally did a quick edit on it because if it weren't for adding this on, I would have had 25 minutes of cases. So this is going to be a surprise for both of us. And I need to go get Ava, and some guy's asking about the couch that I had the dude put on the curb. So I have to respond to that real quick. I have to go see if the couch is still there. So I will be right back. I hope this is good. I really do. I'll be right back, guys. I love you.
We're set today in this matter for a sentencing hearing. Mr. Allen pled guilty to 1 count of possession with intent amphetamine, methamphetamine greater than 10 grams, but less than 50 grams, a Class D felony. He did so on January 9th, 2026. The court ordered a pre-sentence investigation report. And the court has received that report. I have reviewed the report, and now I'm quickly going over to see if I noticed anything myself that jumped out at me as a material mistake that would. The court did not note anything of concern. I believe we are dealing with 43 grams of methamphetamine. I'm not sure if is that the lab?
Yes, it's 43.07 grams.
43.07 grams of methamphetamine. I have received and reviewed the pre-sentence investigation report. I have late received the sentencing memorandum for Mr. Allen, but I have reviewed that as well. I do not believe that there was anything else for the court to review. I don't have anything off the top of my head about any character references or anything of that nature.
Your Honor, I did reach out to Cliff Cassidy and Mark Peterson for letters of support. They have a prior relationship with Mr. Allen. However, as of this time, they've not provided me with letters of support to that effect.
Is anyone making any statements here today?
I had asked Mr. Allen's supporters here if they wish to make any statements. They indicated they did not wish to speak.
All right, thank you. Mr. Vila, then I'm going to turn to you for your sentencing recommendation and argument, please. And before we begin, I believe that something was discussed between counsel, and then it was stated off the record by Mr. Feliski that there would be a now joint recommendation, even though the state is capped at the PSI recommendation. It's now going to be a joint recommendation argument to the court.
That is my understanding. I'll defer to defense, obviously, on that.
Certainly. To elaborate on that, Your Honor, after review of the pre-sentence investigation, its contents, as well as the recommendation made, and discussing this case with Mr. Allen, he indicated that he was frankly quite comfortable with the recommendation by the PSI. We had an agreement, as the court noted, for the parties free to argue with the state capped at the recommendation of the PSI. But given the circumstances here, I believe a joint recommendation under the circumstances would be appropriate.
All right. Okay. Thank you.
Thank you. So just to briefly remind the court how we got here, this was a situation where officers made contact with Mr. Brandon Allen at a gas station. There was a suspicious issue regarding the motorbike that he was on with the license plate not matching the motorbike. He had a black bag in his possession, tried to dispose of the black bag. When law enforcement finally recovered it, they found the 43 grams of meth inside. So the DOC here recommends 5 to 6 years in the Wisconsin state prison system, broken down as 3 years of initial confinement, followed by up to 3 years of extended supervision, stayed and imposed in favor of 5 years probation. That's what the state's arguing for, and apparently that's the joint recommendation. So 3 years of initial confinement, 3 years of extended supervision, imposed and stayed in favor of 5 years probation. The goal of this sentence should center on rehabilitation and deterrence. Going through the PSI, it's quite apparent that Mr. Allen has no substantial criminal history really of any kind. He has a couple low-level theft cases on his record. He completed a 7-month supervision term related to one of the thefts that took place in 2003. The case at hand here today is obviously a very large step up in exposure in the criminal justice system. With that in mind, I believe the court needs to address Mr. Allen's substance abuse issues while also taking into account the gravity of the offense and the need to protect the community as a whole. As the PSI correctly points out, 43 grams is a significant amount of meth.
Big ton.
It's a big amount of meth. So the court needs to therefore impose this sentence that provides Mr. Allen with the opportunity for programming, but on the other hand, hefty enough of a punishment to properly reflect said seriousness of said offense and the need to protect the general public. The carrot or the stick metaphor, so to speak. Ultimately, that's what the state's arguing for is 3 years of initial confinement, 3 years of extended supervision, imposed in the state of 5 years probation. Thank you.
Thank you. I'm going to need a hefty argument as to why I should follow the recommendation. This is an S ton. It's a lot of ton of methamphetamine, a lot of ton that this is an intent to deliver, a manufacturing and delivering 43 grams of meth. And that was not denied. This is a lot of ton of meth. A lot of meth.
Thank you, Your Honor. I'd first like to address the issue of credit. Mr. Allen was brought into custody on this offense July 10th of 2025. He was then released on bond on October 29th of 2025. He then was brought back into custody on this matter on December 4th of 2025 and has remained in custody thus since. By my math, I have 223 days of custody credit. As was noted by the parties, Your Honor, this originally wasn't a joint recommendation. We were going to be free to argue. I communicated that as much to Mr. Allen that we could argue for time served. We could argue for a lesser sentence. We could argue for a lesser sentence with probation. We were free to argue whatever sentence we would like. In review of the PSI, what struck me about Mr. Allen's response was how much he was willing to accept it. As the court noted, this is a substantial and extremely serious matter. This is a substantial amount of illicit controlled substances that were located on Mr. Allen. There's a reason that this is a Class D felony. There's a reason that the maximum penalty for this type of offense is so high. As the court has often noted, methamphetamine is a plague on this community. It's a plague on this country as a whole. I'd go even as far as to say that it is a plague on society writ large, no matter where you go. It ruins lives. It destroys people. It breaks apart families. It is fundamentally incompatible with a peaceful, polite, law-abiding society. Mr. Allen has spent 223 days, every second, every hour, every moment, sun up to sundown, thinking over his accountability, his responsibility to society, to this community for the commission of that offense. And in reflecting on that, Your Honor, I think he understands first and foremost that this needs to be the end. This never should have gotten to this point, but this case, this matter, this needs to end here and now, because if it does not, Mr. Allen knows that his life is on the line, his family's life is on the line, his
Wasn't there a series about this? I do recall something very familiar.
children's life is on the line in his absence, in the ways that his actions impact and affect them directly and indirectly. This needs to be the end. And it's out of consideration for that. It's out of consideration for his need to address the substance use issue, which I believe, Your Honor, is at the heart of this matter, of Mr. Allen's past criminal history. It's the need to address the coincidental mental health issues relating to grief and trauma. These are the reasons for why we are going with the joint recommendation for an imposed and stayed sentence with probation. Because Mr. Allen understands that he needs to be held accountable. He needs supervision. He needs someone looking over, making sure that he is doing what he needs to do, what he has to do in order to reintegrate into society. He understands the gravity of that. He understands that, frankly, this PSI is a gift. It is unusual for it to make a recommendation in this manner. I think in large part why it does is that it identifies what the core issue fundamentally here is, which is, again, I would say a coincidental mental health and substance use issue. As the PSI and as the sentencing memorandum noted, Your Honor, this all seems to have started when Mr. Allen lost his brother in the line of duty. His older brother, my understanding, served in Iraq and tragically lost his life there. From that point, from what I can tell in my conversations with Mr. Allen in review of the PSI, it seems that a cycle began to emerge. He took substances to grapple with the pain, the grief, the anger, the trauma. He realized that he had a substance problem. He addressed it, moved on with his life, and then encountered another crisis. Once again, he relapsed, went back to methamphetamine, realized it was a problem, addressed it, moved on. Same thing happened. Crisis, relapse, readdressing, moving on. The point I'm making here, Your Honor, is that I think the PSI in part characterizes Mr. Allen as not taking this seriously. And I think under the circumstances, I can understand where that perspective is coming from. But what I would clarify on this is that he's not minimizing this. He's recontextualizing it. He understands that this is not simply an issue of I use meth and I need to stop using meth. It's an issue of I'm using meth because there's something inside of me that's broken that I don't know how to deal with. And he's kept coming back and back through that cycle again and again because of that underlying issue. In the time that he's had, Your Honor, to sit and think about what got him to this point and what he needs to do and what has to happen going forward, he realizes that it's both. It's addressing the substances. It's addressing the substance use. It's addressing the environment that he's in regards to the people that he's around and the relationships that he builds. But it's also about understanding why it is that he ends up there. It's about understanding what he needs to do to avoid getting there. An ounce of prevention, Your Honor, is well worth a pound of cure. I think Mr. Allen understands that. And I think, again, in light of that, that is why he does wish to have a joint recommendation here and accept probation along with this very, very hefty sentence.
So, if an ounce of prevention is worth a pound of cure, what does that translate into grams of meth?
In the course of my representation of him, Your Honor, I believe Mr. Allen is at his best when he's helping others, when he's out in the community, when he's developing positive relationships, when he's around positive people. I think that's when he shines. I think that is the key here that will unlock a very bright future for him. I think he's driven and ready to succeed. I think he demonstrated that by being the first inmate to graduate here at Burnett County Jail in the HSCD program. I think he demonstrated that, as was indicated in my sentencing memo.
For those who don't know, HSCD is high school equivalency diploma. It's apparently just a niche above a GED in terms of recognition.
With his intent to get healthcare and follow up with employment programming. One additional thing that I did note, Your Honor, and that has been noted by this court before, is the issue of association. When imposing a sentence, it's critical to assess how long or how short that can be and what the ramifications of that decision can be. Too short of a sentence, they're not learning their lesson. They don't understand the gravity and weight of what they did. Here, my concern would be that if Mr. Allen were to immediately enter into a substantial length of custody, that what that would do unintentionally would lead to him creating bad relationships with bad people. It would put him in an environment without supports that he needs from positive people in the community that are going to keep him out of this type of behavior. With all that having been said, Your Honor, I think looking at the Galleon factors here, that the recommendation by the parties with the PSI is appropriate. The recommendation for an imposed in-state sentence of 3 years of initial confinement and 3 years of extended supervision is a substantial amount of time hanging over Mr. Allen's head. He knew that it could have been a far higher amount by entering his plea to begin with. He's here today to take accountability and responsibility for what happened and understanding that he needs this incentive, this stick, so to speak, to keep him accountable. In protecting the community, Your Honor, Mr. Allen is agreeing with the recommendation here for 5 years of supervision through the department. That's a substantial period. That's a very, very long time for him to be on his absolute best behavior, because he is well aware and knows if he doesn't do well on probation, if he doesn't do what he needs to do to address this underlying problem, he's going to have no choice but to have to address that problem in a confined setting in custody. I think here the recommendation for an imposed in-state sentence with probation is appropriate stick and carrot.
How about a shit ton of jail time? He can get the stick there.
Mr. Allen will have access to programming through probation that will allow him to address this underlying issue and keep him involved and invested in the community. Again, if he's not able to do this on his own, this recommendation will ensure that he must address it by being revoked and sent back into the prison system. In regards to Mr. Allen's rehabilitative needs, Your Honor, I think again, the PSI statements by the state and by the defense here make clear that this is at its heart a substance use issue. Mr. Allen knows this, he acknowledges it, and he's doing everything that he can in his position thus far to address it, and will be doing everything he can once he is out of custody going forward, whether that happens today, tomorrow, a year from now. In my conversations with him, Your Honor, I picked up on a few things. The most important detail is one that to me is very indicative in my line of work about whether I'm going to see someone again or not in this role. And that's that he acknowledged that he has a problem. He's not trying to duck responsibility, Your Honor. He's not trying to avoid taking accountability here. He's agreeing to a substantial amount of probation, and he's agreeing that if he doesn't meet those terms and conditions, if he doesn't do well, if he's not on his very best behavior with the department, that there is going to be a punishment for it. Put differently, Your Honor, I'm in a line of work where a lot of people want to avoid trouble. They want to avoid a certain outcome. They want to avoid accountability. They don't want to go to prison. They don't want to go to jail. They don't want to do probation. They don't want to pay a fine. They don't want to do programming. They don't want to do anything that someone is going to make them do. That's not the case with Mr. Allen. Mr. Allen knows that there's a problem here and that he knows he needs to address it. He knows that if he doesn't address it, it's not going to go well for him. It's not going to go well for him here. It's not going to go well for him going forward. He is extraordinarily blessed to have a loving and supporting family through his mother, through his children who have been with him, who have stood by him, who have said, despite this, we know your heart.
His wife left him, but that's besides the point.
We know your character. We know this isn't you, and we understand that you need to take accountability on this, but we're here for you. I think that was when Mr. Allen is released from custody, I have full confidence in his ability to succeed. It would cause me a great deal of pain if he were not to do well. I don't mention that often because, frankly, I don't like to get personally involved in these sorts of matters, but Mr. Allen has struck me. He struck me as someone who made incredibly poor decisions and ended up in a situation where his very life was on the line, and still is. He's handled that with grace, with candor, and he's ready to put his best foot forward, Your Honor. I think the agreement here reached by the parties is appropriate. I think it addresses the galleon factors here sufficiently, and I would ask this court to follow the agreement. Thank you.
Thank you. Mr. Allen, this is now going to be your opportunity to tell me anything that you think I should know, anything you think I should consider, things that you think may need to be corrected or need to be stated in more detail or depth. You also need to tell me, because I'm interested in knowing whether or not you have any treatment lined up, whether or not you have a plan for the future, what it is that you're thinking. And if you're reading a statement, I need you to read it slowly. I need you to enunciate your words. My court reporter needs to be able to take everything down, and I need to hear you.
I'll try my best. I'm kind of.
If it's emotional,
nervous.
take your time, stop, take some breaths, then continue.
Well, okay, I wrote this a little while back. When asked about my true feelings about this incident, I don't feel as though I've been able to fully express myself or to be interpreted as I see fit. I feel writing my true thoughts under stress is the best way. So here goes. I hate drugs. I despise crime, and I cannot stand criminal behavior, which leads me to the feelings of constant regrets, depression, and full hypocrisy, feelings that I struggle with daily. I follow all the laws to the best of my abilities, which have gained me my best reputation and rapport with those that I have in my life. Knowing what pleading guilty would fully do to my life, my reputation, my credibility, all that I've worked my whole life for, I still chose to be 100% honest and accountable for this crime. Not for sympathy or any other angles, but because it's the right thing to do. I committed this crime, and I don't believe in wasting anyone's time by taking it to trial or attempts to downplay it, because that's who I am and who I will always be. A 100% honest and genuine person struggling with my own demons. It's hard for me to express in words the full effect that my time in jail has taught me, or the way it's redefined my moral compass, because it is something that's in my every thought, every second of every day. Webster's dictionary defines the word accountable as follows, as an adjective, being the one who must meet an obligation or suffer the consequences for failing to do so. I feel as though the past 8 months I have paid for this many times, with many seconds spent regretting my actions, as well as feeling the sting from my guilt and remorse with those I've hurt and have had to suffer with me being in here. Guilt, remorse, the feelings of responsibility for wrongdoing, regret, self-reproach, shame, and penitence are all feelings that come to my mind at a regular basis while waiting for my sentencing. The world did not stop spinning since my arrest and has created a world for me to face at a different level upon my release, which I am learning to do so daily. My reasoning for drug use has been nothing short of an excuse to mask my true feelings over grief and loss, which from learning from fellow inmates in here, I am fully capable of overcoming given my new outlook on my life. Taking it upon myself, I have developed my own personal program for handling my feelings geared towards overcoming the feelings which I've spent the majority of my life masking. Preventative mentality is all I have to offer to prove this cannot happen again. All stemming from what I believe to be the most important question of all, not asked during my PSI, was what I have learned while being in jail. I've learned more in 8 months than I have from any treatment program, learned from observing and empathy. I can honestly say with all my heart that I do not belong in any facet of life other than being a loving and present father, son, and a man who sets examples to follow and strives for success in all things. You asked me if I had any plans for once I am released. I know that there's a couple of places in town here that are offering like Aurora, I believe it is, for help getting my Badger care up and running, which would also help me with my education. Ultimately, outpatient treatment is something that I would be seeking. I'm not quite sure if it'd be through Superior or if there's any more places local. I spoke with a lady a little while back about psychotherapy.
You need psychotherapy for sure, but you also need intensive inpatient treatment, not outpatient treatment. It's too easy for you to reoffend doing outpatient treatment. It's too easy for you to continue selling with outpatient treatment. You need intensive inpatient treatment that you can't violate.
Possibilities of looking into that. Work, I got an application all set to go today to the bar/restaurant that I worked at, but not as a bartender. It would be in the kitchen. Basically trying to do my best to slowly plan it out so I don't bite off more than I can chew, but at the same time, keeping myself and holding myself accountable so I don't put myself in a position that is gonna basically start everything all over again. While in here, I started that by basically blocking and deleting my entire friends list on SIDNet, with the exception for my mother and good friend Jennifer behind me. I believe that that was the start of it. I believe that if I'm not in a setting or if I'm not around people that are using, I'm 100% confident that I will succeed in this. Mr. Feliski did say that one of the when I'm most happy is when I'm helping others. I even came up with a program that I thought would benefit felons or addicts, but in doing so, I realized that maybe I should hold off in helping addicts until I'm able to help myself.
Yep, that's a big one.
So I mean, I want to help everybody. I always do. I mean, my mother will tell you that, but yeah, that couldn't be more real to me right now. I'm not ready to help people. I am ready to help myself though. Thank you.
Thank you. There is no ifs, ands, or buts about it at all, not one bit, that this is a very serious matter, extremely serious. No question there. 43.07 grams of methamphetamine, weighted grams of methamphetamine. That is an S ton, and I'm just not swearing here. That is an S ton amount of meth. 3 grams is intent. You can get charges for intent and deliver, for selling, for dealing. 3 grams. You had 43 grams of methamphetamine. That is not a little bit of meth. That's a lot of methamphetamine. A lot of methamphetamine. So very serious, out of the gates. I was jaw dropped when I read this presentation report. My jaw dropped when I read the recommendation. I'm gonna be honest, I'm gonna be blunt, I always am. Mr. Allen, you are a likable person. I like you. I truly do like you as a person. Me liking you and me doing my job and what is right in my job are 2 different things. I like you. I respect the fact that you worked extremely hard to get your GED. So proud of you. I cannot tell you how much that means to you, to your family, and it means something to me. You did that. You didn't have to do that. You could have sat in jail and you could have just sat and twiddled your thumbs and wanted the time to go by, but you took advantage of the time you had in custody and you got your GED and you helped others doing that. You helped others succeed and accomplish that too. So there are many things about you that I like, I respect. I think you are a good person. I see you have a good heart. I've seen your family come and support you. I've seen your daughter thrilled when you got your GED. I've seen those things. Those things make you human to me. I try and have everyone that's seated in that seat right there be a human to me and not be black and white paper. Because black and white paper, then you're simply looking at all of the bad and not allowing to see the good. I see the things and I understand to the best of my ability with my personal experience, my professional experience, and all that I've gathered in my many, many, many years on earth, that there's more to a person than the black and white. All right. And you have to take all of that into account. And for me to do my job and to do my job well, I need to see you as a human, as a person who has faults, who has issues, who has the good, the bad, and the very ugly. And that comes into account in all of my sentencing. So I see you. And I hear your words. To me, I'm going to tell you, and again, I'm going to be blunt. I liked them. They're good. They came across. They had a good, that was a good topic, good foundation, good things to back it up. It seemed like you were giving me a speech. The dictionary defines. This is what it says. It seems like you were trying to sell it to me that you do understand, or that you get it and this is what it is, and like you're trying to sell it to me that you're telling me what I want to hear or what I should hear in order to follow the recommendation, because that's where we should go, and let's go on probation. I've heard more heart from you at your GED graduation speech than I heard in that. And that was supposed to be a speech. This is supposed to be a, hey, judge, this is where it is and this is what's happening. It's not supposed to educate me on what the dictionary defines something as, or what I should see, or how I should see it, and where it should fall into play. This is where you are essentially begging for your life. And you should be telling me all of the things that you've already planned. I've already talked to Teen Challenge. I've already talked to, Betty Ford. I've already talked to the place in Florida. I've already talked to the place in Texas. I've already done these things. I've already arranged and set up a treatment, an inpatient treatment facility with a bed. And it's lined up if I'm able to go. And that is at the mercy of the court, and court, please see this, and I've set it all up and this is what I've done. I don't hear that. I see individuals who have substance abuse issues every day. But I'm going to tell you and be honest, I don't see them sitting in that chair, people with substance abuse issues in the chair like you are today. 43 grams of methamphetamine.
That's because he killed them all. Otherwise, they'd be sitting in that chair.
You do not have an extensive criminal history. I think there was like two thefts or something of that nature. Nothing big. I don't know if that's because you haven't been caught at doing things. I don't know if you really do follow the law and you just slipped. I understand pain. I understand loss. I understand death. I understand feeling like you want to give up. I've been there. I've had loss too. I don't turn, nor has many other people seated in that chair with substance abuse issues turned to 43 grams of methamphetamine and intent to deliver, and that devastation and destruction. They turn to self-medicate, and they self-medicate, and they have, and they do, but not all of them sit in that chair with the heaviness that you have on your shoulders today, that you placed on your shoulders today. And you were given a chance on bail with certain conditions. You violated those conditions. Wham, bam, straight right back to using methamphetamine. And I think, didn't you say your cat died? That's why. And that was the reason, that was the excuse. And it's a poor excuse, your cat died. And so you went back to methamphetamine. Instead of reaching out to somebody else, instead of trying to go to your mother, instead of looking for a meeting or any other thing, your cat died. And so you're like, blah, I'm giving up now. I'm going to use again. When you knew you had so much on your shoulders at that time, so much to risk and to lose, $2,500 in cash that I believe your mother put up, that the court had every legal right to forfeit and to say bye-bye to that money. But I didn't, because I knew that would actually hurt your mother. I get it. Pets are like children. I had my pug for 17 years. I lost her. It's hard. You reach out to other people. And at that time, at that particular time, you had also told the court you have learned all of these things that you recited in your letter. And I get there are relapses. I do the treatment court. I get those types of things. But not everybody has the weight on their shoulders that you do. 43 grams of methamphetamine. Mr. Filiski made a good statement in his argument. He has went to the depths of his soul to argue for you here today, because he knows how serious this is. And he made a really good statement about your associates, I believe, that his association and who you associate with. He's very correct. And I have heard you say that you've went and you've changed, you've deleted all the people out of your phone and out of your contacts and all of those kinds of things. You haven't been out of custody long enough with this over your head to have those kinds of things fully sink in yet, because you've been in custody. It's so much easier to maintain your sobriety, to have the positive outlook, to do those kinds of things while you're in custody. But once you are out of custody, you don't have that confinement. You have forced sobriety right now. And you don't have that confinement to ensure that you're not going to use. And again, that's why the treatment is important, or a treatment aspect is important. And it shouldn't be upon me to tell you to look at those things or to get a plan or to have something in place just in case, or if the court were to go along with probation. It's not on your attorney, but you know, that could be a way to try and have the court follow a probation recommendation. It's on you. You're the one who is changing you. You're the one who has to look at making your life better and doing better and showing me that you're not going to be a threat to my community, that you're not going to be a devastation of destruction to this county or to any other person. And all I've heard is, well, maybe there's Aurora, maybe there's some other outpatient things in this county, maybe there's things. I don't think you've went through that process of admitting to yourself that this is real and this is really serious, and you are fighting for your life.
Oh, he's probably still high.
And I stressed to you, as I stress to everybody that I take a plea with, especially a plea of a serious nature like this, that you understand, I'm not bound by anything. I'm not bound by this recommendation. I'm not bound by the state's argument. I'm not bound by Mr. Feliski's argument. I'm not bound to listen to your plights and requests. I'm not bound. And the reason I'm not bound is because my job is to look at the community, the public, the interest as a whole. I have to look at you in the first process, in the first part of this, and am I protecting your constitutional rights? Are you getting everything that you're afforded, plus any victims that are here? But then after that, I have to look at the community, protecting the public, and those types of things. And when Mr. Feliski was saying changing the associates or your association, you have to change. And I didn't hear that in there. I heard the skirting around it or the brief touching of it, that you want to do these things, but you have to do these things. You have to change your habits, the things you do, the things that you do that are so ingrained. You have to change your associates, the people you're with, not just removing them from your phone. You have to change those. And then you have to work on changing yourself. That is the only way you're going to significantly improve your life. You can't surround yourself with people who are putting you in those types of situations. You must surround yourself with people with who are positive supports that can influence a positive change and who can help you align with good, positive goals. That's the only way you're going to change your life. Again, I have to weigh certain things, the nature and the gravity of the offense. This is very serious. I have to look at you, your character, your past criminal record, which is very slight. I have to look at other things like rehabilitation. Do you have rehabilitative prospects? Are there other things out here? Your age, your education. I have to look at your culpability. I have to look at this crime itself. And then I have to look at needing to protect the public. with a crime like this. And then it comes down to other factors such as deterrence. There's specific deterrence. I need to have a punishment that not only deters you specifically from doing anything like this again or anything similar, but I have to look at general deterrence, something that's going to generally deter others and say, you know what, why would I even engage in that? If I do, wham, bam, slam the door, okay? Because this is so serious. I have to look at deterrence, you and generally others. And in this deal, I've heard the arguments of the state, and the state is bound. They are 100% bound. They could not go into it. Mr. Vila did not go into any in-depth about anything. He's bound by this recommendation of probation. I've heard the arguments of the defense, and it was very heartfelt, very full, very solid. And I also heard your statement to the court. And I've read the criminal complaint, and I've been here throughout the entire process of this case. You have a felony bail jump that was dismissed and read in. All in all, you have these two charges that, if found guilty on both of those charges, you would have the maximum possible penalty of 31 years of incarceration. You didn't get the greatest of all, great of all deals, and I'll admit that to you. And you pled guilty to the charge, I believe, that you were charged with. You pled guilty to the intent with the possession with intent, amphetamine, methamphetamine, greater than 10, but less than 50 grams. And that was the charge that you were charged with. You got rid of a possession of drug paraphernalia and then that felony bail jump. So it's not like you got this sweet deal. You got a good deal. You did plead guilty, and that shows something. All right, you pled guilty, you accepted responsibility, and you were like, hey, I understand, I did this. It's hard to fight 43 grams of methamphetamine. It's hard to do that. And so you are taking that responsibility. And I do give you credit for that. Not everybody in that seat would do that. So that goes on the positive favor for you. But here, the dispute here today with sentencing, I have to look at, is this a prison sentence? Is this an imposed but stayed prison sentence? Is this simply a probation with a withheld sentence? And I do have the joint recommendation of all three of these entities coming together arguing for an imposed but stayed with probation. And so I have to determine what is a correct sentence here. What is it that I need to look at? If I'm looking at probation, I have to look at certain things. If I were to place you on probation, I need to consider, if I put you on probation, there's multiple things that I have to think about because probation is the first thing to consider. Now, would you need confinement? Do I need to confine you to control your criminal behavior, to stop you from doing criminal acts? Do you need some type of treatment, and can you get that treatment outside of a confined setting? Or does it look like the confined setting is the only way that's going to force you to have you get the treatment that you need? I have to look at, if I put you on probation, would it unduly depreciate the seriousness of the offense? Okay, those are what the things that I have to consider. If I do a sentence of confinement, it has to be the most minimum amount that's consistent with the protection of the public, looking at that, with the gravity of the offense, the seriousness of this offense, and your rehabilitative needs.
And as we learned the other day, they can't impose the absolute maximum punishment and do a term of probation. So there has to be a little give and take in there on the sentence in order to be able to still impose probation. So there is that factor as well.
And I know the facts that is alleged in that criminal complaint. I know the statements that you've made. I know that you first said that this was personal use. 43 grams is a whole lot of personal use. That's a whole lot of grams of methamphetamine. And it's hard to have people understand that the size of 43 grams compared to a regular personal use amount without me showing the displays that I have, but it's a lot. 43 grams is a lot of methamphetamine. That's way beyond personal use. And so if you look at that and what the intent is behind that, again, that is participating in the devastation and the destruction of our county. I don't have any history that you've done that before. I don't have a history that you've engaged in other things before. But again, I don't know if you just haven't been caught or if this was the first time. This is the first time, man, you have the worst luck ever. Because that's a lot of methamphetamine. Again, I think you have a good heart and I think you are a good person. I think you've done some really stupid and dumb things. Some devastating things. And so in a case like this, I've reviewed the PSI multiple times. You started using methamphetamine when you were 15 years old. You're 39 now. Nothing has changed. What has changed? And I've heard that you've made these steps to try and change your life and get on a better path.
What has changed? My guess is the potency, probably the concentration, dosage. Yeah, that's probably changed. And my guess would be it's increased. Chemical composition. Sometimes they use gasoline, sometimes they use lighter fluid. I mean, typically there's some cleaning agents in there, whether it was cooked in the bathtub or the toilet. I mean, lots of room for change.
But it's been 24 years. I haven't heard a concrete plan of you're going to engage in treatment. You've made the plan for this treatment. You've looked at this service and you've looked at these things and you're looking down this path. And I can't sentence probation. I can't. It would unduly depreciate the seriousness of this offense. It would send a terrible message to the community. It will not meet the deterrence factor of deterring others and you from engaging in this type of behavior. There has to be a punishment factor. This is a punishable sentence, a punishable crime. 43 grams. But I am taking all other things into account because I've said all of those positive things for you. I feel you can change. I haven't been shown again that you have made the steps to do that, and you need something to move you in that direction to do that. So this is a prison sentence. And it doesn't make me happy to do this, but I have to do my job. This could be up to 15 years of initial incarceration and 10 years of extended supervision, maximum possible penalty, 25 years. The $100,000 fine potential. What the court is going to do is I'm sentencing you to 1.5 years of incarceration with 5 years of extended supervision. Anything else would unduly depreciate the seriousness of the offense. And it's at 1.5 years of initial confinement simply because of all of the positive things I see in you, Mr. Allen. Otherwise, it would have been far more. But I cannot, with this seriousness, do anything less than 1.5 years of initial confinement. $518 in fines and fees. You do have more of that in bail, but child support is requesting that that be allocated over to your child support as you owe a significant amount in child support. So the court is directing that the remainder go to your child support. You have to work that out with your mother. And that is for case number 11 FA 70. When you are on extended supervision, well, first I'm going to say I'm making you eligible for the substance abuse program or the challenge incarceration program. And another reason I did a year and a half instead of just a year, because I was considering that, is because that gives you enough time to get in, get processed, and get doing that program. So apply right away. Because I have not seen, if I had seen you or heard you come in and say, I have Teen Challenge arranged right now, I have the place in Florida arranged right now, I have this place arranged right now, if it's a go from the court, that would have weighed things a little bit differently. But without that, with knowing the seriousness of the crime, I cannot. And I have to look at other options and other things, because I'm going to tell you again, I understand and I feel your pain when you lost your cat. But if that was enough to have you jump right back to using methamphetamine, I don't know what is going to help you not, without actually having the resources. And if you're going to start using again, chances are highly likely that you're going to go down this path again. And I can't have that.
I truly expected her to give him more. I'm not gonna lie. I like Judge Mogan, but I'm a bit disappointed.
No use or possession of any illegal drugs, substances, or paraphernalia. Absolute sobriety. No bars, taverns, or liquor stores. This includes employment purposes unless approved by your agent. No contact with anyone with any drug-related extended supervision or probation unless approved by your agent. Absolutely zero contact with anyone who has intent to deliver or possession with intent of any type of drugs at all. Gainful employment. Testing upon reasonable or regular testing. Any programming as required by your agent. AODA assessment and follow through. Mental health and therapy evaluation and follow through. I'm ordering your DNA. You have the ability to request it be expunged through a written letter to the Department of Justice. I'm not sure this classification allows you to have it expunged, but you can request that. 223 days of jail credit. 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. This is a felony. No use or possession of any firearm. No voting until your civil rights are restored. I believe that covers everything, Mr. Vila.
I believe so, Your Honor.
Mr. Felisky.
I believe that covers it, Your Honor.
All right, thank you. Mr. Allen, I truly meant everything that I said positive about you. I truly do think those things. I have to do my job.
How can you have 43 grams of meth and only get a year and a half? It's not enough. With any luck, he'll violate probation and get the full 5. I really just can't even believe that. And she talked like she was going to give him a long sentence. She really did. But there's a lot that we didn't see. I mean, we only know the black and white fact. He had 43 grams. Claimed it was personal use. Bullshit. Absolutely. Bullshit. Well, guys, my internet just did the spinny thing. I'm not going to risk it. I'm going to say goodnight now because I don't know if it's going to stay up. I realize this and I'm not happy about it. YouTube's been doing some weird things. I know. So I am I know, I'm sorry. I'm gonna call it a night. I think YouTube is to make sure it did it again. Okay, guys, sorry, it's not me. It's not me. Be safe, be well, sleep sweet, and much love.